Hello, and thank you so much for joining our webinar, Sidestepping Fiduciary Landmines, Essential Guidance for 2025. I'm Alex Asley, Managing Director with Hub International Retirement and Private Wealth, and thrilled to have you join us for today's session, an important discussion on some of the key issues and key fiduciary considerations when it comes to retirement plans. Before we jump into today's conversation, let me just review a few details. First of all, we are recording this session and we'll send the link of the recording to all of the registrants tomorrow. And secondly, your feedback is very important to us. So after the webinar, you'll see a survey pop up before exiting the dashboard. We really encourage you to take a moment to let us know how we did, what other topics you'd like us to cover, and if there are any questions or follow-up items that you'd like to share with us. So let's get started. I'm pleased to be joined today by Fred Reish, partner at Faegre Drinker, Biddle and Reith. Fred, of course, is a nationally recognized ERISA attorney. He is a legend in our industry and the leading authority on fiduciary responsibility, plan management, and compliance. He's received multiple accolades and lifetime achievement awards and advises plan sponsors, service providers, investment advisors, and practitioners on fiduciary best practices and regulatory issues. Fred, thanks so much for joining me today. I'm excited for our conversation, talking about some of these key items that we want to make sure we cover to help professionals, advisors, plan sponsors implement prudent and compliant retirement plan programs. So these are the top agenda items of what we'll make sure we cover today. What are the core considerations for retirement committees? What are responsibilities that committees should be thinking about and taking action on throughout the course of a plan year or calendar year? And then some updates on Secure 2.0 legislation, litigation trends, and other items that are really important when it comes to prudent management and retirement plans. Fred, again, welcome, and I'll have you take it away for us.
Hey, Alex, thank you very much, and hello, everybody. Alex, I'm not going to let you off quite that easily with your introduction. Alex is one of the top retirement plan advisors in the country. So you're going to get, me as a lawyer talking to you about what the law is and the things you need to be paying attention to legally. And you're going to get Alex talking to you today about how he actually works with plan sponsors and the fiduciaries, for example, as plan committee members to implement some of these laws in a way that doesn't get the plan sponsor or the committee in trouble. So as context, just to set the foundation for today's discussion, I want to point out that the officers and managers at a company who oversee the operation of a plan, who make decisions about the operation of a plan, the investments, the service providers, the costs, the fees, and all of that, those are fiduciaries. I mean, and that has a very specific meaning in the law. Several courts have called it the highest standard known in the law. They're talking about a standard of conduct. And we'll get into that in more detail as we go along. But I'm going to refer to those today as plan committees. Now, you may just have one or two people at your company that make decisions about the plan operations, but for ease, let's just call it plan committees because that's pretty common. That means you have duties, and those duties that are the highest known to the law are the duties of care or prudence on the one hand, and the duty of loyalty on the other hand. I think sometimes it's hard to keep in mind as a fiduciary that you have a duty of loyalty. You as an individual have a duty of loyalty that runs directly to the participating employees. You have to act in their best interest. Okay, now let's try to breathe a little bit of reality into this by looking at a court case, and it's the NYU case, New York University. And we're going to look at, in effect, at the good, the bad, and the ugly of the plan committee members' conduct as the judge wrote it up in his decision. So let's start off looking at that case. The judge first, and this is the actual opinion, this is the decision that the judge wrote up and is in the records into perpetuity. I've taken out the names because I don't want to talk negatively about anybody. But the names actually appear in the opinion. So these people's names are written into the law now in a way that you don't want your name written into the law. So the judge starts off by saying, talking about the chairwoman of the planned committee, her testimony was concerning. Well, I tell you, that tells you the rest of what the judge
Mm.
says about that committee member is going to go real south real fast. He goes on, she made it clear that she viewed her role as primarily concerned with scheduling, paper movement, logistics. She displayed a lack of true appreciation of the significance of her role as a fiduciary, as a committee member, as subject to the highest standard known to the law. Um, Basically, the judge said she saw herself as a ministerial person rather than as a fiduciary acting on behalf of the participants. He went on to say she appeared to believe that it was sufficient for her to blindly rely on the recommendations of the plan's consultant. Uh, that's there case after case that says what the judge said then. As a matter of law, blind reliance is inappropriate. The fiduciaries make the decisions. They can use experts, advisors, consultants to help them, and they must use experts where they don't have the knowledge themselves, but they have to get the recommendation from the expert. They have to consider it. They have to ask questions about it, engage in conversations, and then make the decision. It's a planned committee's decision, not the provider's or the advisor's decision in the typical case. So um, that sort of brings us, starts the case off in a bad way. But then the judge went on and talked about another committee member where the judge, again, this I'm quoting from the court's opinion. The judge also found the testimony of another committee member was disturbing because she didn't understand the role of a fiduciary. She didn't know what fiduciaries were supposed to do. And she just didn't seem to have a grasp of the job. Um, at one point in her testimony at trial, she said that the reason she couldn't remember some of the details about the plan committee and its decisions was because her role on the committee was one of just many responsibilities that she had. Well, that never should have been said. That is the wrong answer to give a judge in a trial on fiduciary responsibility. The judge said this suggested that she did not view herself as having adequate time to be a fiduciary, to make the decisions, to fulfill the job of serving on the plan committee. So now that we've heard about two plan committee members, what did the court decide? Okay, if we move right along, here's the court decision. It's shocking. After careful review of the record, the court finds by a preponderance of the evidence that while there were deficiencies with the two committee members we just discussed, um, the plaintiffs have not proven that the committee acted imprudently. Why? After everything I just told you, how could the court have concluded that? Well, if we go on to look at what other committee members did, there were two others. I'm just going to tell you about one, but they're similar. The one committee member was also the CIO, the Chief Investment Officer of New York University. She saw her role as providing specialized knowledge about investments to the plan committee. She testified that she questioned the investment consultant. Can you imagine that? She asked questions. Well, there's actually almost a legal duty to ask questions. Certainly a legal duty if you don't know, for example, what a share class is. And your advisor is talking to you about a share class, or your providers are talking about share classes, or revenue sharing, or institutional, or retail, or so many different things that are somewhat unique to the investment and 401k world. If you don't know what those all mean, there is a duty to question. There's actually a court decision about a duty to question. Anyway, she testified that she questioned the consultant. Great, that's what's expected. And she wanted to know the basis for their opinions. Why were they making the recommendations they were making? She wanted to know why, and they answered her. Outside of the committee meeting, she read plan materials. Believe it or not, I don't want to really say there's a legal duty to read plan materials, but I can tell you get in a lot of trouble if you don't read the plan materials. So think of it as a legal duty. Yeah, when you get those materials, you have a duty of loyalty and prudence that runs to the participants in the plan. That means you need to be aware and you need to know what's going on. So anyway, so she met with the consultants independent of the meetings and asked some questions. I don't think you actually need to go that far, but you need to act that way in the plan committee meeting. So There was another committee similar to her, a committee member. Then the court concluded that NYU was not liable because the court found that while a couple of the committee members effectively gave the judge legal indigestion, uh, the other committee members performed their duties well enough that they saved, and this is not a legal term, but they saved the bacon of the misbehaving committee members. So which ones do you have? Do you have some of both on your plan committee? If you do have some like the first two that we talked about, I suggest you have fiduciary education and that you help them be educated on what their responsibilities are such that they could answer the questions differently than those two NYU committee members. And Alex, do you provide fiduciary education to your plan committee members when you meet with them?
Yes, absolutely. And one of the comments that you made, or that was notated in the summary of this case, is that several of the committee members, one in particular, explained that they have a lot of responsibilities within the company, and from a practical perspective, that's common, and we see that with a lot of the organizations we serve and the leadership team or finance and HR executive team members that serve on these committees. But that notwithstanding, it's important to have a process and a support system to help them both recognize the importance of committing time towards the role as a fiduciary with respect to the retirement plan and on the committee, but also provide them with knowledge and training so that they're well equipped for these meetings to ask the right questions, to understand how to be efficient with their time in those committee meetings and deliver the degree of skill, care, prudence, and focus while in the meeting. And so we provide ongoing fiduciary training to our committee members, especially in the scenario where we have a new client relationship, a new organization that we engage. And even if they feel that perhaps they've done some degree of training in the past, as a good foundational reset to helping them understand what the key role and responsibilities are when you're serving as a fiduciary or when you're serving as a plan sponsor to a retirement plan. We also help do that when there are new committee members that join the organization so that they can get accustomed to the processes and the prudent process, if you will, that committee has fulfilled or followed historically, a good foundational preparation for joining the committee. Frankly, there are a lot of ways that you can deliver this type of training. You can, throughout the course of the year, provide events like an all-day training session, or as part of a review meeting, a subset of that meeting being some sort of training, informal or formal, around that. We also have on-demand, self-paced videos. But from my own personal opinion, the best format in which we deliver this fiduciary training is we get the committee together once a year. We dedicate 60 minutes, 75 minutes, and take them through those core components of ERISA with respect to their fiduciary duties to help remind them of that role, and then also provide them with information, keeping them apprised of changes in regulatory, legislative, or specifically sort of litigation trends when it comes to retirement plans.
Just to add one thing to that, Alex, I think one of the most difficult and awkward things I've ever done as an ERISA attorney was to go talk to the CEO of a company who was regularly missing committee meetings because he was so busy, and actually having to say to him, I really think you should not be on the committee. I was afraid he'd say back to me, I don't think you should be our ERISA attorney, but he didn't. He took it to heart, and he understood what I was talking about, and made the right decision, which was he got off the committee because he didn't really have time for it. But that's what you want. You want people who are actively engaged and involved in the committee meetings. So good. There's just to move along and try to go from what your duties are in a legal sense to talk to how you actually deal with some of these responsibilities. You have a legal responsibility first to know what decisions you need to make. In some ways, that is the hardest single thing because you don't know what you don't know. And
Hmm.
that's where an advisor like Alex can really be helpful to you because this is their bread and butter. Those top advisors do this all day, every day, and they know all the decisions you're going to need to make over a course of a year. We won't have time today to go into all of those, but we'll give you some examples. And then duties, any continuing decision has to be monitored. What's a continuing decision? We have an investment in the plan. Should it stay in the plan? You've got a record keeper as a service provider. Is that record keeper continue to perform well? Are their costs reasonable? Are they doing the job right? Those are monitoring responsibilities that along the way you need to monitor all continuing decisions that you make. Um, some of those are, as I already said, the costs and the quality of investments and service providers. Um, but we can't really just give you a list. There's no formula that says, hey, here's
Hmm.
everything you need to do. Uh, but one way to effectively create a bit of a list like that for yourself is to have quarterly meetings with quarterly agendas. And if you set those up more or less in advance, then through the year you'll make sure you cover all of the agenda items. Issues may come up that you'll add to one agenda over the course of the year, but at least you have the core of it there. Here's some examples. We'll just give you an example or two for each quarter, but there's more than this. It would be that 60-minute focus that Alice was talking about. We could be on this and this alone. Um, okay, quarter one, right now, we're in the first quarter of the year. Uh, an example would be this would be a pretty good time to review the investments, the quality of the investments. Are they performing as expected? Have there been any manager changes? Are the expense ratios appropriate? Do you have the right share class? A mutual fund may have, I don't know, some of them may have as many as 8 or 10 share classes. Those are different expenses. Same pool of investments, just with different expenses associated with them and for different purposes. I would bet most people listening to this don't know what they all are. I don't know what they all are. But somebody like Alex does, a top-notch retirement plan advisor would be able to help you figure out which is the right one for your plan and your circumstances. A $10 million plan is one thing, a $100 million plan is another. Though it varies a lot based on plan size and also based on how you want to pay the expenses of the plan, revenue sharing. So, but that's a good quarter one example to go through that. That would be on the agenda as well as other things. Quarter two, uh, okay, I said earlier you have to monitor the service providers. That's in my hypothetical. It doesn't have to be this way. These are just examples. In quarter two, look at the expenses and the performances of the service providers. Uh, and we'll get to a little bit later on when I talk about litigation about how you do that, because I'm going to ask Alex to explain how you actually look at expenses of service providers. Um, quarter three, fiduciary education. Okay, we've already talked about that. What are your
Hmm.
legal duties? Just what's the basic blocking and tackling of being a fiduciary? What are the current litigation issues? Let me tell you, every couple of years, different issues come up. And later on, I'll mention one that's sort of the hot topic of today. Uh, what about DOL investigation priorities? We'll talk about a couple of the current top DOL investigation priorities. If they come in and investigate you this year, they will ask questions about those two things. We'll talk about that a little bit later on. And then what about retirement plan industry developments? If we were having this conversation 15 years ago, other than for the very largest plans in the country, we probably wouldn't be talking about collective investment trusts.
Right.
That's what I mean by an industry development. Things change, cost arrangements change, investments change. Anyway, things change in the industry as well as in the law. So take a look at that. That's where, again, you can't, if you make widgets, you shouldn't know that. But for a top retirement plan consultant, they do know that. And that's where they can help you. They can help you with the unknowns, the things you don't know you need to do. And in fourth quarter, just something I've put in, this is a best practice, not a legal requirement, plan metrics and ideas for improvement. Let me give you one quick example. Um, your industry, whatever industry your company is in, most of your competitor companies have a level of participation that falls within a fairly narrow range. Some are higher, some are lower. Where are you in
Hmm.
that scheme? How are your employees embracing your plan by participating in it? There is data out there. And if the data shows you're underperforming, or if the data shows you're at average, but other companies are better, and you say, how can I be better like these other companies? There are techniques in the industry for improving almost any aspect of a plan. Uh, so that's why I threw in that example. That's a best practice. You don't have to increase your participation if you're doing all the legal part right, but it's not a bad idea to do it. So those are just examples. I don't want to beat that drum too much, but I think those are helpful examples to give you an idea of how agendas might be structured.
And
So yeah,
and Fred, I'd say, retirement committees have this dual responsibility. We're really focusing on the fiduciary responsibility, right? The legal responsibility that the fiduciaries or the committee has to manage the plan in compliance with the law, prudently and objectively in the best interest of participants. But there's the other duty to deliver a benefit that is valuable, a retirement program that helps employees make the best decisions for their financial goals to help them save and accumulate money for retirement. And frankly, so when you talk about that idea under Q4, plan metrics and ideas for improvement, while not a legal requirement, another thing we often talk about is employee engagement, education, financial wellness services. Those are not specifically or explicitly required under ERISA, but providing certain information and information and resources to employees so they can make informed decisions is a requirement for protection like 404C. However, I would say that these are collaborative responsibilities. The best run plans, the plans that are generally in the best shape from a compliance and governance perspective, happen to usually be the plans that have the greatest degree of focus on their fiduciary responsibilities as well as their outcomes and delivering value of that benefit. And so one of the things that we do, hub advisors every year will work with committees, will work with their client relationship. We put together what we call a project plan. And it's essentially a version of this, identifying all of the different uh, types of review, analysis, and action items that we will fulfill collectively or on behalf of a client throughout the course of a year, and when those initiatives, when those specific reviews or actions will get fulfilled throughout the year. So it serves as a great tool to not only demonstrate how we're working together to manage the plan and fulfill our fiduciary duties, but it's really a report card of progress and identifying, when we're going to be fulfilling these different either requirements or strategic initiatives with respect to the plan.
yeah, Alex, I agree. I think it's interesting. Complying with the law by the fiduciaries um, aligns with the employer's desire to not be sued, to
Hmm.
not be liable or not be investigated. But these best practices you were talking about how do we improve our plans, how do we have better employee engagement, how do we provide greater value, how do we get the company to be more appreciated by the employees because they can tell we're concerned about them. There, the alignment is positive. It's not a negative, we don't want to be sued alignment. It's a positive alignment of how do we have the best workforce and retain the best workforce possible. So I think what you're saying is great. That makes a lot of sense to me.
And one of the best takeaways of what you were mentioning earlier when we were on this slide that I think sometimes is a little misunderstood or muted in some committees is that that retirement plans evolve and best practices, trends, and even legal requirements change, right? We're going to talk about that here in a few minutes on Secure 2.0, on other fiduciary and lawsuits and DOL investigations. Sometimes when we're meeting with committee members, they may have a position that they was told to them at a training session or by an ERISA attorney 10 years ago of why they might not want to add automatic enrollment in their plan because of the legal risks that exist in automatic enrollment. And now there have been advancements in safe harbors around some of those legal risks. There's common correction programs, just as an example. but my point to this is sometimes um, both advisors and committee members have sort of this um, viewpoint that may not have evolved with the evolution of the retirement plan marketplace, with the just sort of competitive nature of the industry to create more innovative products and or new regulatory or legislative changes. And so that's why it's always important as a committee, as a plan sponsor, to reassess the design of the plan, reassess the goals for your plan, reassess the way you're structuring your pricing, all of these things that have drastically changed in the last, 10 years, let alone the last 20 years, as the 401k and 403b plans have become the primary retirement savings vehicle for America's workforce.
Good stuff, Alex.
So, do you want to let's talk about what some of those changes are, what some of the activity has been from a litigation perspective and even a DOL perspective.
Yeah, folks, there's a constant drumbeat of ERISA litigation where plan fiduciaries are sued, alleging that they have made mistakes, fiduciary mistakes of one kind or another. And we'll get into some specific examples in a minute, but also the Department of Labor is out there investigating plans. And they may also assert a fiduciary breach if they run across something that they find troublesome. So, Alex, let's go ahead and look at some examples of the ERISA lawsuits. For at least 10 years, and actually probably fairly longer than that, plaintiffs' attorneys have been suing fiduciaries of 401k plans, saying that they have overly expensive investments, and particularly the wrong share class, and that their record keepers making way too much money off the back of the participants, often because of revenue sharing, which fiduciaries may not know they need to monitor. So those have been around forever. Let me mention two more, and then I want Alex to talk about what plan committees can actually do to comply. But the new claims are improper use of forfeitures. Your plan document has a provision that says if an employee leaves and they're not fully invested, that amount that's not vested is forfeited. And what can you then do with that? Now, let me say, if your plan vests people 100% from the beginning, you can just tune this part out. It doesn't apply to you. And if your plan says forfeitures must be used to offset employer contributions, you can probably tune us out too. Or if it says forfeitures must be used to pay plan expenses, and that's what you're doing, then you're probably in good shape. But we find two problems. One, it says there's a case right now where the plaintiff's attorneys allege that the plan document said forfeitures must be used to pay plan expenses, and in fact, they were used to offset contributions. There's a legal duty for fiduciaries to administer the plan according to its terms. If that's correct, that could be a difficult lawsuit. There are a bunch of lawsuits out there right now where that forfeiture provision says the money can be used to pay administrative expenses or to be reallocated to participants or to reduce employer contributions. Notice those ors. The key words are the ors in what I just said. That means somebody's got to make the decision. Which one? Who's making that decision at your company? And is the decision being made in the best interest of the participants? Because several courts have held that is a fiduciary decision. And fiduciary decisions have to be made in the best interest of participants. That doesn't mean you have to decide one way or another, but you got to decide what's best for the participants and have a good reason for it. Okay, that's forfeitures. Imprudent selection of target date funds. Those lawsuits are there, but by and large, the plaintiffs aren't particularly being successful. But I will say there's a document released by the DOL several years ago called Tips for Selecting TDFs. It might be good to revisit that. And at the very least, two things to look at. Do you have target date funds are designed? They're not all alike. They're designed and they're different. Some are conservatively designed. Some are aggressively designed. Some are designed to stop their glide path, stop getting more conservative at retirement. Those are called to retirement plans, target date funds. Others continue all the way out to older ages, well beyond retirement. Those are called through retirement target date funds. A plan committee going forward, because of this new litigation, plan committee should be prepared to answer the questions. Is your TDF suite conservative? If so, why? The ones that get sued right now tend to be conservative. Why? Because between about 2011 and 2020, the market just went up, 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 up.
Right.
And so conservative target date funds look bad. But courts have said no if the plan committee selected a conservative fund because they felt that was better for their workforce. And an example might, let's say, a tax exempt organization with low paid people who are unsophisticated on investing issues and who work there forever. Really good people committed to the charity. That might be conservative, or that could be a reason a committee could say we think is conservative. What about aggressive? What about a law firm like one that I'm at? High income people, you can work till older ages, you can deal with volatility in a down market, on and on. There's a different, or a company with a pension plan. Yeah, maybe aggressive there because they've got a pension plan's like a giant bond. Anyway, those are conversations. I'm not saying I'm right or wrong. I'm just saying that's stuff you may want to talk about. So Alex, I've mentioned overexpensive investments, overexpensive record keeping, forfeitures, target date funds. Pick your poison and give us some insights.
I think this slide is where everyone who's joining us today has some really defined takeaways to work on in 2025, and I'm excited to get your insight and expertise a little bit on this, Fred, because the one area that has been a bit of an eyebrow raiser for us is around the improper use of forfeitures. Right, these have just started to pop up. I'll touch on the other two absolutely. I think there are really good, consistent processes within the industry that we can deliver on investments, on target date funds, on expenses, and I'll explain how we do that. But I think for a long time, plan sponsors and committee members and advisors alike have felt that the usage of forfeitures, as allowed in the adoption agreement, provided that organization with flexibility to determine which way they were going to use those forfeitures. To your point, there are some courts who've identified this as a fiduciary decision in the past. There have been some who believed it was a settler function, right? That it was not deciding whether you were going to use your forfeitures to offset a match or pay plan expenses was a decision that would be a business-related decision by the organization. So one of the things that's interesting that we've found in helping our client relationships just put a lens on this is that some service providers, some of the vendors that we use to provide retirement plan services that we're providing their plan document, their base plan document and adoption agreement, they may have language written into the base plan document that kind of identifies the flexibility of using for any of those purposes. Others have a format in the adoption agreement where you're checking a box saying, we're going to use forfeitures to offset our match or our employer contribution. And Fred, to your point, our view is that first and foremost, the retirement committee and the fiduciaries should just have a really good understanding of what does our document say is allowable, is permissible, and how we can use forfeitures, and ensure that the committee is following that. And then in the scenario where there's optionality, determining what would be the most prudent use of those forfeitures and mitigating or minimizing risk. So as an example, if you really are only going to use those forfeitures to offset a matching or an employer contribution, then we would advise let's not select that you may use it to provide an additional contribution to participants, or you may use it to pay for plan expenses if you never intend to do that, because some of these cases, that's where the target or the focus has been on the plaintiff's attorneys. My question to you, Fred, just on this is, the payment of plan expenses. So, today, retirement plans, it's permissible that reasonable plan expenses can be paid through the plan, by participants. So these could be expenses such as the record keeping and administrative expenses for a service provider, or the consulting or advisory services delivered by an advisory firm like ours, It could even extend to things like an audit cost, right? So in a scenario where there are some expenses that are paid by the employer, let's say, for example, our advisory compensation is paid by the organization. It doesn't flow through the plan. But there are other expenses like the record keeping expenses that flow through the plan and are paid by participants. And the plan accrues forfeitures. Is it your view that those forfeitures, if they're going to pay reasonable plan expenses, they should first be paid to be used to offset those expenses that are paid by participants?
Uh, Alex, for context, everybody, full disclosure, we're defending some of those cases. We're
So
defending
you might not
plan
be able
sponsors.
to opine on.
So I have a bias. But in response to Alex, I mean, my personal preference is that the all expenses be paid by the plan and charged to the participant accounts because I favor full transparency. Over the
Mhm.
years as a lawyer, I have just become a fan of full transparency. If there are forfeitures on top of that that can be properly allocated or used, they can, and follow the terms of the plan document. If the terms of the plan document say they are to be allocated at that point to participants, then fine, show it as an addition to each participant's account
Mhm.
at the end of the year. But I do have a bias, Alex, and above me, I'm being a lawyer. I have a bias in favor of full transparency. So,
Yeah, no, that's a
uh,
great point.
yeah, yeah.
I didn't, and I know I put you on the spot there, but it's just such an interesting sort of flag that's been raised, red flag for a lot of plans here recently because of this is a newer claim. Well, let's spend a few minutes on the other two areas there. So, first of all, that first bullet point is that it's been probably more like 15, if not 20 years that there's been a series of high-profile class action lawsuits against 401k plans, generally focused on expensive investments or fiduciary breach due to excessive compensation, excessive fees, right? So one of the things that we do is that every year we go through a full plan cost analysis and benchmarking. And so we help committees understand the overall cost of the plan and how that cost compares to a peer group, a defined peer group, perhaps based on size of assets, size of company, number of participants in the plan, but a reasonable peer group. So we create this universe independently analyzing the overall cost of the plan compared to peers. And then we look at the cost for the individual components of the plan. So the record keeping and administrative costs, the advisory compensation, the investment expense. And to your point, Fred, we're also big fans of full transparency in pricing. So generally speaking, while there still exists the ability in some instances of cost savings or arbitrage by using investments that have revenue sharing, we tend to favor lowest cost institutional investments, removing any and all revenue sharing as much as possible, so that it provides us a very clean, transparent pricing structure. So we go through that analysis every year with the committee, and there's to date, because of the fee disclosure 408b2 rules and regulations, there's a lot of data available to do this, to do it effectively, efficiently, and to have a good benchmarking. And then we work with the committee to identify the services that are being delivered and the value for those services and how you can assign value to the services based on the costs, so that we've again gone through a process, we've documented it and identified if we feel that the cost for the services are competitive in the marketplace. And I think that provides a really good baseline to adhere to both the 408b2 and fee disclosure requirements, but also to manage the fiduciary duty of paying reasonable plan expenses.
And just to add, Alex, to what you said, and I agree with it completely. The rule is that you can only pay reasonable expenses for investments or plan services from the plan
Right.
itself, or from the investments. And but reasonable, the way the courts have interpreted it is there's a range of reasonableness. So it's not like you have to have the exact dollar amount. And Alex's comment that they be competitive is exactly right. You need to, within that range of reasonableness is what's competitive. So I just wanted to point out, those extra little details and say you were spot on what you said, Alex.
And then I think the selection of target date funds is also a really relevant topic because really it's not only the selection of target date funds, it's really the selection of the QDIA, right? The qualified default investment alternative, which can be a target date fund, and today the majority of plans use a target date fund as the QDIA, but not all plans. However, we're also now in this sort of next evolution of retirement plans. I don't know if you want to call this 401k 3.0 or 4.0. I'd have to think back of the first time I saw you present, Fred, actually, is not far from where I'm sitting right now in Bethesda, Maryland, early in my career in 2007, I think, on the Pension Protection Act. That might have been the start of 2.0, I think. Nonetheless, we're now in this environment where there's, a lot of discussion and interest on other types of do it for me like investments, like managed account solutions or professionally managed portfolios, or in addition to target date funds. But nonetheless, I think this is an area where not only are we reviewing the investments with regularity with committees to have a consistent, objective, frequently applied process that follows generally accepted investment methodology, kind of a framework for how we're analyzing investments that are offered in the plan with alternatives. But then in addition to that, we need to have a process to review an all-in-one, do-it-for-me solution like a target date fund that perhaps changes over time as somebody gets closer to retirement, especially when we're using that as the default fund, as a fund that we intend to meet that QDIA safe harbor. And so at least annually we go through that process and we look at that option that we're providing to the plan that might be, or that is the default fund in particular, and how it suits the needs of that organization and their employees. And you brought up some great criteria. Is there another benefit plan like a pension that the organization offers? Are there unique factors based on the demographics of the workforce? These could be age demographics, income demographics, tenure with the organization, and having a process to analyze some of those factors to demonstrate and document that you reviewed the target date selection in a way that it still makes sense as the offering you're providing to those participants.
Alex, just to, again, second what you're saying, if you go through the process that Alex just described, I don't see any, and you say, okay, a conservative target date suite is better for our employees, or an aggressive target date suite because of such and such, the demographics. I don't see any court ever saying, oh, no, we know your demographics better than you do. Mm-hmm. So it's the process that's critical on this point. Are you going through the process? And does your decision make sense? Not is it perfect? Not would the judge decide something different if it were the judge making the decision, but does it make sense? So, pick up on what Alex said and make sure to go through that process as a 2025 issue for your plan.
Yeah, I think as we're spending some time in this session, this is a really good takeaway. If we're trying to think about actionable takeaways for a retirement plan, this is one I think really would be a focus of every committee to have a process for that. Now, there are a few other things we want to shift into here. So why don't you talk, Fred, a little bit about some of the Department of Labor investigations, what they're focusing on more recently?
Sure, and I picked a couple that might surprise you a little bit. The first is missing participants. You might ask, what the heck is a missing participant? They're really talking about somebody who used to be your employee, but no longer is, but they left their account balance in the 401k plan. So the money's still there, but they're gone. If you can't locate them, or if you try to locate them and they're unresponsive, that's called a missing participant. So either they're truly missing in the sense you can't find them, or they're unresponsive. If the DOL comes in and investigates you, they will say, Do you have addresses for all your participants? Are you giving them all of the required disclosure information each year, like the quarterly statement, the annual 404A5 disclosure, and so on? If not, the Department of Labor will assert that you have breached your fiduciary duties by not keeping in touch with people and providing them with the required disclosures. I was doing the kind of fiduciary education Alex and I have been talking about to a plan committee a couple of years ago. And I did this as part of it. I talked about missing participants because it was a brand new issue then. And the chairwoman of the plan committee turned to the representative of the record keeper who was in the meeting and said, "Oh, you guys take care of this for us, don't you?" And the record keeper representative said, "We do if you ask us to, but you've never asked." If daggers from eyes could kill people, that would have been a dead representative of a record keeper. It turned out they had over 100 missing participants, former employees with account balances behind. We spent a year tracking them all down. Let me just very briefly describe, and there's a link on the slide to where you can see what the DOL says about this. But just very briefly, there's 3 steps. Step number 1 is look at your internal records. Look at the designation of beneficiary. See if for health insurance or under COBRA coverage, if you've got another address. Just look at stuff internally and see if you can find the person that way. Number 2, look at stuff externally, but with your internal people. Facebook, LinkedIn, Twitter, now called X, Instagram, whatever, social media, the internet, stuff that you can do internally. Third, if you don't find them in the internal and those 2 internal steps, go external. External, I mean a commercial locator service. Now that may sound a little bit like a black hole to you right now, but it doesn't need to be, because as far as I know, every record keeper has a contract. Your primary service provider for your plan has a contract with a commercial locator service, and they can they will work with you to use that service to find people. We ultimately found, I think, virtually everybody out of those 100 or so. Now, some were dead, and we found their errors. But ultimately, I believe we found everybody as best as I can recall. But it took a lot of effort. Better to do this on an ongoing basis than all at once, the way I described. Then very quickly, I'll mention cybersecurity, and we'll let Alex jump in with the reality of how this works. Cybersecurity is the number 1 issue now. I'm involved in defending another big DOL investigation on cybersecurity issues. But from a plan sponsor perspective, the DOL has issued 3 pieces of soft guidance. Soft guidance means, hey, here's what we think you should do, not there's a legal duty to do this. Clearly a legal duty to oversee cybersecurity issues. But okay, number 1, cybersecurity program best practices. That is essentially about what the plan sponsor should do. And number 2, tips for hiring a service provider. That's about what a service provider should do. What I've seen some plan committees do is send that tips to the record keeper saying, what are the answers to all these questions on here? Now the record keeper will come back, and most of them I think have pre-prepared responses, where they won't respond to certain things because that would sort of tell how to get into their system, and they're not going to tell that, but they will respond to most of it. And these are evidence you can have that you're paying attention to your legal responsibilities. Number 3, online security tips. That's for participants. In a perfect world, if I were a plan sponsor, I would send that out once a year to all the participants in the plan saying, this is a reminder, and it's baby stuff, like don't let other people know your login information. Keep your login information in a confidential place. Don't leave it out. But most of the cases I'm aware of, it has been a participant who's caused the problem. So even though those are baby steps, that can be, record keepers tell me they're getting thousands. Each record keeper tells me they're getting thousands or tens of thousands of attempts a day to break into their system. So your biggest friend is your record keeper. And participants, in this sense, are your weakness, your vulnerability. So, Alex, that's my limited experience. What about you?
Yeah, we essentially take that sort of prescription that you just laid out and review that with committees and really impress upon them the importance of following through on each of those three actions consistently or each year. And I would agree, just to start with the last piece, the online security tips. This is, I don't know the data. It's a massive percentage, but the spirit of this, what I'm about to say, is what matters the most. Is that the majority of cyber fraud, bad actors accessing, identity theft scenarios comes from sharing of passwords or weak or reused passwords across your digital footprint. So think of it, you want to go buy something from a online retail clothing store, and you've got to create a username and a password, and you use, just a simple password that and then you go and you have some sort of app on your phone that you use for fitness, like counting your steps or going for a run, and you got to have a username and you set up the same password there, and then you just use that same password on your 401k or your bank account. It's generally not going to be the 401k vendor or your financial institution that gets data hacked. They're not totally immune to that, but they usually have the controls and the processes in place. It's usually that other app that you use for you're going for a run that gets the data hacked, and then they now have access to your username and password, and the bad actor just throws that against all of the other websites out there, and that's how they get into your 401k, or that's how they get into your bank account and can, commit fraud or identity theft, steal assets from you. So that baseline is really important. We impress that upon committee members to distribute out, to post on your networks these online security tips as part of the Department of Labor guidelines. The other two pieces, cybersecurity best practices, it's kind of like the corporate version of what I just mentioned. So if there are multiple people within an organization that serve as an administrator to a 401k plan or a retirement plan, and they've got to go into that vendor website to process payroll contributions, to approve certain actions like loans or distributions, and to prepare compliance testing, each administrator should have their own username and password, right? The sharing of usernames and passwords is a big no-no in terms of cybersecurity best practices. So making sure committee members are aware of that. And then we, to your point, Fred, ensure that we reach out once per year to the service provider, vendors, third-party administrators, and have them provide a response to the questionnaire, the Department of Labor guidelines for hiring a service provider. In many cases, we're also capturing the available information that they'll provide on certain controls and testing, like their SOC 2 Type 2 reporting, that talks about the controls they have in place on their platform to protect data, who has access to reading, writing, overwriting that data. All good information that you can then document, store in safe records to demonstrate that you've looked at and you're taking cybersecurity seriously. All right, I know we're coming up on the end of time, and there are a few items with Secure 2.0 that you want to make sure we touch upon as well. So I'll let you run through these, Fred, and talk about what's on the horizon with Secure 2.0.
Sure. First off, Alex mentioned earlier the word settlor, and that comes from the Old English. That means whoever sets up the plan. So that's the settlor. And plan sponsors can design the plan within the law in the best interest of the company, not the participants. A settlor decision is how to design the plan, how much to contribute, those kinds of issues, whether to terminate the plan. They can be done in the best interest of the company, where fiduciary decisions have to be in the best interest of the employees. And as we said earlier, there's a requirement that you follow the terms of the plan. Having said that, we're in a really crazy situation now where Secure 2.0, and for that matter, Secure 1.0, amendments to your plan don't have to be made till 2026. So you now have to operate your plan in the way that it will be amended in 2026. In other words, you've got to make decisions now about complying with mandatory requirements and make decisions now about whether or not to comply, offer voluntary or optional provisions. So let me give you some examples. The long-term part-time employees, this is mandatory. You have to be operating consistent with what I'm about to tell you. In Secure Act 1.0, which was enacted back in 2019, required that long-term part-time employees have to be included in 401k plans for at least deferrals. You don't have to put company money in, but you have to allow them to defer. It's a long-term part-time employee is part-time is 500 or more hours a year, but not enough to be a full-time employee and get in the regular way for 3 consecutive years. That was 1.0, and that became effective January 1, 2024. If you didn't do that last year, and you should have, then you've got a problem, and you should talk to your advisors, providers, and lawyers about how to fix it. Then along came 2.0 and said if 3 years is good, 2 years is better. So at least 500 hours for 2 consecutive years. Those people should have come in on January 1, 2025. So here we are a couple months later. If you didn't bring them in and should have, you've got a problem. Talk to your advisors, providers, and lawyers about how to fix it, because you really do genuinely have a problem. 2.0 also extended the LTPT concept to 403B plans. So that's private sector 403B plans, like private universities, private schools, that sort of thing. Same thing. That, although for them it only applies January 1, 2025, because it wasn't part of 1.0, it was only part of 2.0. Now, if we go on to the next provision, we'll see that it's an optional provision. You don't have to do this, but I think you probably want to do it. The Secure Act 2.0 said you can allow some of your older employees to put in even a bigger catch-up contribution. The regular catch-up contribution now is $7,500. So if you're old enough, you can, on top of your regular 401k deferral, you can put in another $7,500. However, beginning in 2025 this year, for if you're turned 60, 61, 62, or 63 during the year, then your catch-up limit is increased to $11,250 if the plan sponsor decides to allow you to put that additional amount in. Have you decided that as a plan sponsor? You don't have to do it, but if you want to do it, and why wouldn't you? You can do it. But you need to make a decision if you haven't already made one. And if you want to do it, then you need to communicate that to your employees that are affected by this. Those will be 60, 61, 62, or 63 this year, and then again next year and the year after that. Once you hit 64, though, you're out of it. You can't, you're back to the 7,500. It's a crazy rule. It was done for tax purposes, for balancing the budget type tax purposes. Okay, the final one, we're back to mandatory. This is beginning in 2026. Why are we talking about it now? Because you're going to have to make decisions and communicate things beginning probably decisions in the middle of the year. I would say communicate in September, October at the latest. So yes, this is a 2025 decision. Mandatory though. Beginning in 2026, catch-up contributions for 401k and 403b plans must be treated as Roth contributions, meaning there's no tax deduction to the employee for deferring, but they ultimately, if they leave the money in there for at least 5 years as a Roth, when they take it out at all, plus earnings comes out tax-free. This only applies to employees making more than $145,000 in 2025. So you'll know this year, they'll know if they're impacted by this or not. There's no choice. It has to be Roth. However, it only applies to wages, the Social Security definition of wages. What does that mean? If you're a sole proprietor, it doesn't apply to you because you don't have wages. If, like me, you're a partner at a law firm, it doesn't apply to me because I get a K-1 partnership income based on profits. Why? We don't know why. I think Congress just made a mistake and they used the wrong definition. It sure wasn't to prefer law firms over people who receive earnings from companies. Anyway, however, if you don't already allow Roth deferrals for all of your employees, then you're going to have to in 2026. What if you don't want to? Then your higher paid, more than 145,000 employees cannot make catch-up contributions. So that's your choice. Either stop them from making catch-up contributions or allow Roth contributions for everybody. So we moved through that pretty quickly, but Alex, here we are on our last slide. Feel free to add anything to this.
Well, these are two big changes from the Secure 2.0 law from 2022. We found the special catch-up contribution on that prior slide that the vast majority of our client relationships have added that this year. In fact, many of the service providers or vendors had a default, opt-in provision where if you didn't told them that you had to tell them you didn't want it, or they were automatically just going to offer it as a function on the plan. And most payroll providers, not all, but most payroll providers had an automated solution on how to account for that. But it's definitely something to keep an eye on, communicate out to those employees who would be able to make that additional contribution, and just keep an eye on the deferral limits this year, especially for those who fall into that category. This one, the Roth catch-up contributions, is a big area of focus with our plan administrators, the team members who are responsible for a lot of the day-to-day operational processing of plan contributions in coordination with a payroll provider or an HRIS system. And I know that we have it on our roadmap this summer to really engage with each client's payroll provider and make sure that we have the process in place to be able to identify who would be required to make a catch-up contribution as Roth in 2026, how to identify them in the system, and how to ensure any contributions they're putting into the plan as catch-up are going in as Roth and not pre-tax. So certainly some work that will need to be done there as well. A good thing to have on your radar, probably takeaway number 3 from the session here today. So I know we're at our time. Fred, is there anything else that you wanted to add as a closing? I know we've covered a lot of great information. Anything in particular that you wanted to make sure the audience today has as a good kind of reminder as they go into the next steps of making sure they're managing their plan in compliance and prudently?
Sure. Alex, one quick thing. The law says that the standard of care for fiduciaries is that of a knowledgeable person and knowledgeable about everything we've talked about today. But the law goes on to say you don't actually have to have the knowledge yourself. You can hire consultants, advisors to fill in the gaps where you don't know how to do some of these things. Just make sure you're hiring a high quality, independent advisor who doesn't have any conflicts of interest. So, and who's experienced in this area. So that's it, Alex.
Excellent. Fred, great to see you as always. Thanks so much for joining today's session and all of your expert feedback and counsel. On behalf of Hub International, thank you all for attending today's webinar. If you have questions that we didn't specifically address or follow-up items you'd like to learn more about from today's webinar, please feel free to add them to the survey or reach out, and one of our team members at Hub will follow up with you. Again, as a reminder, we ask that you please fill out that survey before you close out your GoToWebinar browser, because your feedback will be valuable in helping us to deliver valuable future events and webinars for you. Thanks again, and this now concludes our broadcast.